that the state was communicating with your client.
Your viewpoint that you were representing Mr. Copeland in this case, meaning the case that's on trial before Judge Whitaker?
Yes.
As a witness or as a potential co-defendant?
Yes.
Okay. And that the Honorable Court knows, I believe, but to your knowledge, who is Don Geary in 2021?
What he introduced himself, I mean, I knew Don for a long time, but what he said, he was special counsel for the Fulton County District Attorney's Office. He was basically hired almost like in an of counsel position, as I understand it.
And was he affiliated on working this case that's before Judge Whitaker on trial?
We talked about this case specifically.
At any time, well, I'm sorry.
And nothing else.
At any time, did you or any member of the District Attorney's Office in your presence ever say that you were not representing Mr. Copeland pursuant to a potential witness in this trial?
No.
Okay. Did you ever have conversations with Ms. Love, who is seated to your left?
Yes.
About representing Mr. Copeland as a witness in this trial?
Yes.
And when were those conversations?
March of 2023.
And was it clear from your standpoint, from your viewpoint, as the court said, people can observe things differently, but from your standpoint, was it clear that you made it known to the Fulton County District Attorney's Office that you were representing Mr. Copeland as a witness or potential witness in this trial?
Yes, it was.
All right. Did you do anything to separate yourself from that representation?
No.
All right. The Honorable Court stated a little while ago, and you left here so quickly, but that your representation ended of Mr. Copeland, I heard, in 2023 when you entered some sort of disposition, I don't remember what it was, before this Honorable Court. And when I say this Honorable Court, I'm talking about Judge Whitaker.
Sure, that's correct.
Did your representation end of Mr. Copeland as a witness in this case? Did
No.
you ever make that known to anybody?
No, I never did.
Did you actually do the opposite?
I was contacted by another member of the Fulton County District Attorney's Office in June of 2023.
And about
Yes,
what?
I'm sorry, about representing Mr. Copeland in this, as a witness in this case.
Were there any agreements between Mr. Copeland and yourself in the District Attorney's Office? Because you obviously got him not to be charged. That's a bad way of saying it, but you obviously did someone did something that he's not charged in this case.
I would honestly say that may not have been due to anything that I did or said necessarily. I think it was an internal decision from the DA's office.
Okay. All right. Now, I'd like to show you what I marked, and I just want this for the record. And I marked it number 1, Mr. Williams. And can you announce it just so the court, and we're going to give all this to the court, what this is, if you recognize it.
Sure.
And then go to number 2, 3. But for people looking on, just announce it by the title, if you don't mind. If you don't recognize it, please say that as well.
I recognize this. This is an email I sent to Ms. Love, Ms. Hilton, from the DA's office, yourself and Mr. Schardt, dated June the 6th, 2024 at 4:31 p.m. You want me to read it or?
Sure.
Says, good afternoon. All it has come to my attention that the Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the
Wait, it's way too fast for the court reporter to take down.
You with me? Law enforcement, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Thank you, John Melnick.
Okay. On the 6th, and you made it clear, to your knowledge, was there any type of immunity agreement whatsoever in place? Use immunity, transactional immunity, any type of agreement?
There was no response from the District Attorney's Office to this email to me. So I was not aware of any any offer of immunity to Mr. Copeland at that time.
Did you personally know that if Mr. Copeland testified at this trial without some sort of protection, by protection I mean whatever type of immunity, that he could be making statements that would incriminate himself?
Yes.
No statute of limitations ran, he could be charged?
So I can't say that with absolute.
Okay, well, we're dealing with a bunch of lawyers, so I think Mr. Melnick can handle it. I'm going to overrule that.
I can't say with absolute certainty that I investigated it to the point where I would know whether the statute of limitations would have run or not.
About federal crimes for gun offenses?
No. As far as I know, again, I didn't do extensive research into it, but it's my understanding that it would not have run in terms of the federal statute. And Mr. Copeland, of course, has been charged previously and convicted in U.S. District Court. So the feds, once the feds have their eyes on you, they have their eyes on you.
And how about as a co-defendant in this case being indicted later? And is that limitations barred to that?
I don't know.
Okay.
I don't know with absolute certainty.
Okay. Were you concerned that if he testified when you wrote this email, the one you just announced as Mr. Williams #1, that he could be facing criminal liability?
I absolutely was.
All right. Is that the reason you wrote that email?
Among other things, but that is one reason why I wrote the email.
Was there anything in your mind at the time of sending it that was suspicious or clandestine or by CCing the Honorable Maxwell Schardt or myself on that email?
Not at all. I thought everybody had a right to know.
Okay. And everybody being?
Everybody from the prosecution and the defense team.
Okay. All right. Your Honor, I move for the admission of Mr. Williams #1 for purposes of this hearing.
It's admitted.
Your Honor, can I just get clarification as to which of the emails we don't have the number is defendant Williams #1?
Can you
Yeah.
clarify?
June 6, 2024, 4:31 p.m. to yourself, Ms. Hilton, Mr. Steele, Mr. Schardt.
Does it have the response at 4:57:05 from Ms. Hilton, or is it the one without response?
I don't remember seeing a response.
Okay.
So is there a response on there
There's not a
on
response.
Williams 1?
There will be, Your Honor.
Okay,
Not
so
on Mr.
that
Williams
has
one.
been, for purposes of the record, the one that does not have the response on it.
Okay, so here's the response.
But
Is it a part of Williams 1?
No, it's not.
Okay, so I assume Mr. Steele might ask you about the next one. Go ahead.
and that is, I'd like to show you what's in front of you, Mr. Williams, exhibit #2 for purposes of today's hearing, okay?
Yes.
Tell us, take your time to look at it, tell us if you can identify it, if it's true and accurate for what it appears.
I hope this is from I think exclusively from Ms. Hilton to me.
But do you recognize it?
I do, I recognize
Is that
it.
accurate?
Yes, it is. Yeah.
Okay. Your Honor, I move for purposes of this hearing, Mr. Williams #2, after you identify so everyone knows what you're looking for.
June 6, 2024, 4:57 p.m. I hope good as addressed to me. Good afternoon. I hope all is well. In our conversations with Mr. Copeland, he advised that you were not his attorney and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease communication, but your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we're planning to pick him up. So please make sure that he is present so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. And then it's from Ms. Hilton.
And did you respond to that email? And if yes, is it on Mr. Williams #2, and what does it say in time and date? If you don't.
It is. I did respond. It's dated June 6th at 5:47 p.m. Again, with CCs to everybody in the case. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that that when you were questioning him. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Ms. Love.
Slow down.
I spoke with Ms. Love early in the process around the time jury selection was beginning. I have a plea with Judge Carnicel tomorrow at 9 o'clock, and I will come to the courtroom as soon as I am done.
Is everything that you responded about being Mr. Copeland's lawyer for purposes of this case true?
Yes.
Okay. And the court already admitted #2. If you could go to #3.
Well, no, I haven't.
Oh, I'm sorry. I moved for the admission of Mr. Williams #2.
It's admitted, and that one contains both Ms. Hilton's response and then Mr. Melnick's response back that he just read. Is that correct?
Yes.
Okay, that's admitted.
Okay. This is a repeat, so I'm withdrawing this. Okay. Okay, if we go to Mr. Williams #3, can you take a look at this and tell us whether you recognize it? And if yes, what is it?
It's
Your Honor, if we could just have what that is, and we don't have numbers on it, if I could just have in the court what it is that we are even tendering.
I don't know. I don't know how many things you got handed, but Mr. Melnick's about to describe it.
It's dated June 7th, 2024, 11:52 a.m. It's from me to Ms. Hilton and Ms. Love. The first sentence says, here is a communication between myself and Ms. Love, which pertains directly to the YSL case. And it's a forwarded message from a number of people, including myself and your case manager, Sheila Rosser, dated March the 3rd of 2023. And it's from Ms. Love, stating, good morning, Ms. Rosser. State asks that the defendant be required to sign the conditions in front of a notary or a sheriff's official so that we can enforce the conditions upon his release, since he was not apprised by the court in person. And I'm sorry, that is in reference to 2 bond orders, I believe, that I had prepared and presented to the court in reference to Mr. Copeland's case that was pending before you in 2023. That is an email dated Thursday, March 2nd, 2023 at 4:42 p.m. And this is just a chain of emails related to the bond order for Mr. Copeland's case in 2023.
All right. And you're forwarding that in June of 2024 to say, see, you knew at some point I was representing him. Okay.
That's correct, Judge.
Is that document, is defendant Williams a 3-page document or just the one portion of the chain that you just read?
So is this is a continuation of 3? Okay. There's more to it, Ms. Love.
Is it a 3-page document?
It appears to be, I think it appears to be a 3-page document. Yes.
Yes? Yes.
Yes.
Okay.
Do you need me to, I don't need to read all of this.
No, I don't think so.
We move for the admission of Mr. Williams, number 3, for purposes of today's hearing.
It's admitted.
Why did you, Mr. Melnick, why did you send this to the district attorney's office on June 7, 2024, 11:52 a.m.?
Because of what they claim to be the confusion as to whether or not I was representing Mr. Copeland for purposes of his being a witness in this case. I think these emails demonstrate that I did in fact represent him and that they knew I represented him.
And were there conversations that you represented Mr. Copeland for the witness in the YSL case during that time?
Yes, there were.
And who did you speak with?
Ms. Love.
Okay. And you're responding to Mr. Williams, number 2, that's already in evidence?
Yes.
All right. Your Honor, I move for the admission of Mr. Williams, number 3. It is a 3-page document.
It's admitted.
And I'm going to mark this as Mr. Williams, number 4. Can you take a look at this and tell us if you recognize this?
I do.
What is it? Okay. And what is that?
It's an email that I also sent on June the 7th, 2024 at 11:54 a.m. To Ms. Hilton and Ms. Love, referencing another communication I had from the district attorney's office. It was a forwarded message from Peachtree Offices, which is an executive office company that answers my phone for me, where I got a message from Peter Herzog asking me to contact him in reference to Kenneth Copeland. So it's a forwarded message from June the 27th of 2023 that I then forwarded to Ms. Hilton and Ms. Love, demonstrating that they should have just communicated with me about Copeland before questioning him.
And go ahead. I'm sorry.
And before we got into all this.
And who is Peter? And I'm going to spell the last name, okay?
Yeah.
Herzog. Who is that person to your knowledge?
I believe his last name is misspelled there. I think it's Herzog, but Peter Herzog is the assistant DA in the Fulton DA's office.
And Mr. Williams, what's marked as number 4, is sent for that message on June 27, 2023, about 3 months after the March 1, 2023
Yes.
correspondence with Ms. Love about Mr. Copeland.
That's correct.
Now, if your representation of Mr. Copeland had in fact ended when you disposed of the case before the Honorable Judge Whitaker by that time, do you remember? Did it end?
So my case with Judge Whitaker, is that
Yes.
what you're asking me about?
Yes.
Yeah, I believe it had, but honestly, I haven't gone back to check it.
If y'all have the case number, I can look it up and let you know the disposition date.
I don't have it.
Happy to do that. Nobody has it. It was a 22 SC case, but that's all I know. It's fine. I can probably pull it up some other way. Y'all go ahead.
Okay. And you forward this, you said why? This message.
To reiterate the fact that the Fulton DA's office should have known knew and should have known that I was representing Mr. Copeland for purposes of his testimony in the YSL trial. Mr. Herzog was never involved in the case before Judge Whitaker. I'd never spoken with him about anything related to the case in front of Judge Whitaker. The only attorneys that I ever spoke with about the actual disposition of the case with Judge Whitaker was Abigail Potter, Abby Potter from the DA's office, and Mr. Abadi. And the only reason Mr. Abadi was involved with it, that's Adam Abadi from the Fulton DA's office, was because he was concerned about Mr. Copeland's testimony in the YSL trial.
And obviously Miss Love, because she
and Miss Bond order. Yes, right. And Miss Love the bond order. That's correct.
Okay. Now, I'd like to show you Mr. Williams number 5. Oh, Your Honor, I move for the admission of Mr. Williams number 4.
It's admitted, and for purposes of the record, the case before me where Mr. Melnick represented Mr. Copeland is 22 SC 182134, and the final disposition was actually on June 29th of 2023.
And is the number 4 a one-page document, or are there any more?
It's a one-page document.
Okay, I'm showing you Mr. Williams number 5. Tell us if you remember that, look at it.
I do.
Okay, and is it accurate?
It is.
Can you describe, like you've been doing, the date and time, what it is, what it purports to be?
It's dated June the 7th of 2024. It's to Miss Love and Miss Hilton from me, and it is in response to an email that I received. I'm sorry.
It's okay. You can look at the documents, multiple.
Yeah. Okay. So this is a part of the same chain of documents where I was referencing the fact that Miss Love certainly knew that I was representing Mr. Copeland. She and I talked extensively about Mr. Copeland, and she had told me that she wished to use Mr. Copeland as a witness in this case. Obviously, by the time we were having these communications in March of 2023, the case had long since been indicted, and Mr. Copeland was not charged as a party on the indictment of this case. So this is a continuation of the same emails going back to March 2nd and March 3rd of 2023, where we're referencing the bond orders. These emails actually go back to March the 1st of 2023, where Ms. Love is discussing whether or not Mr. Copeland should be subject to a curfew as part of his bond order. There are, I seem to remember, other communications in which Ms. Love references the fact that she's concerned about Mr. Copeland's safety and the like. And then so the last part of this email, which is at the top of the first page, is where Ms. Love questions whether my concern is for Mr. Copeland or Mr. Steele and Mr. Schart's client, neither of whom I've ever met or have any relationship with whatsoever. And then I responded to that.
Did I ever do anything untoward to affect your representation of your client, Mr. Copeland?
Absolutely not.
Did Mr. Schardt do anything?
No.
Did anybody come to you, at you, about your representation, Mr. Copeland, in this case?
What Mr. Copeland did on June 7th of 2024, where he asserted his Fifth Amendment privilege, was entirely his decision. I was there just as his mouthpiece, as a lawyer, as his advocate for purposes of him asserting his Fifth Amendment privilege. Other than that, I have absolutely no agenda in this case whatsoever.
When Ms. Love wrote on a motion, ex parte motion for the former judge, the recused Judge Glanville,
Yeah,
to grant your client
the introduction through this witness or the posing to this witness of any question about a motion that I wrote, given that the witness cannot testify confidently about anything that I specifically wrote or what I.
All right, well, I don't know yet what the end of the question is going to be, so I'll hold your objection until I hear the question.
and it's in the record. Already, Your Honor, I could get another copy though. Ms. Love wrote in that motion seeking use immunity. under 25-5-507 for Mr. Copeland?
Yes.
That Mr. Copeland on Thursday, June 6, 2024, had some sort of interaction or dealings with members of the defense team. To your knowledge, is that true?
I have no knowledge of that.
All right.
Do you want to admit, or did you want to tender for admission Williams 5?
I do. Yes.
All right, that's admitted.
Thank you, Your Honor.
And Williams 5 is what?
Okay, Mr. Melnick, I don't have any other
Hang on. What are
questions.
you asking?
for
Hang
you.
on, hang on, Mr. Steele. What are you asking? What it is?
Which one is it? Yes.
It's
Just
the last
part
one
of
they
page?
discussed that, I don't know how many pages it is. I don't have any of it in front of me, but it's the last one they discussed that has the email from you asking who Mr. Melnick is most concerned about or something like that. And then Mr. Melnick's rather peppery response back.
Okay, so it's just, could the court ask for clarification, just one page or?
I don't know. 4 pages.
Mr. Melnick, were there any BCC? You know what a BCC is?
Yes.
Okay, I apologize for asking.
Yeah.
Were there any,
We're all old enough to know that that means blind carbon copy. A whole lot of people don't know that anymore since we don't use carbon copies, but that's where somebody can see it, but the recipients who are CC'd don't know.
Yes, I did not blind copy anybody on that last email. I just sent it to Ms. Hilton and Ms. Love. Hilton and Ms. Love.
I apologize.
Yeah.
Any allegation that there was some sort of teamwork or conspiracy against the state of Georgia and against your client, Mr. Copeland, is that true at all?
It is categorically untrue.
All right. I want to thank you so much. I don't have any other questions.
Ms. Love, do you have questions of Mr. Melnick? Hang on just a second.
Just briefly.
Okay, hang on. You have questions too? All right, I'll let Mr. Schardt go.
And those are the court's copies.
Okay.
Mr. Melnick, if you're more comfortable taking the witness stand, that's fine, but, okay.
Mr. Melnick, good morning.
Good morning.
You, as part of your representation of Mr. Copeland, as part of your representation of Mr. Copeland, yes, sir. Did you also make it known? Did you make your representation known to the defense counsel in this case, specifically myself and Mr. Steele?
I did. Yeah.
Okay. In your dealings with the defense in this case, have myself or Mr. Steele ever gone behind your representation, to your knowledge, and attempted to speak to Mr. Copeland without your knowledge and understanding?
I have no knowledge of that. I'm not aware of any time that would have happened.
Since you were alerted about the state speaking to Mr. Copeland, have you read the transcripts from the ex parte communications?
I have mostly read them. I will be honest and say I haven't read the whole thing.
Okay. Have you become aware that Mr. Copeland was speaking to the state in the week leading up to June 7th, 2024?
Yes.
Okay. Have you become aware that Mr. Copeland was in the actual courthouse speaking to the state on that week?
I became aware of that on either June 6th or June 7th.
Did you know anything about that as it was happening?
I did not.
Before you reached out to the state via those emails that have been introduced, did the state ever tell you that they were communicating with your client?
No.
How did you initially learn that the state was communicating with your client?
Are you referencing the week leading up to June 7th of 2024?
Yes, let me ask in a more precise manner. Did you become aware on Thursday, June 6, 2024, that the state had been speaking to your client that week?
Yes.
And did you become aware that the state intended to call your client to the stand on the next day, that Friday?
Yes.
Okay. Did you, and how did you find out about the state's plans to call your witness to the stand?
I believe you called me.
Could you say it again?
You called me.
You being
Yes.
Max Schardt?
Yes.
Okay. And I called you on the telephone?
Yes.
Okay. In that conversation, did I ever ask you to do anything on behalf of myself or Mr. Steele or our clients?
Absolutely not.
Did I ever ask you to stop Mr. Copeland from testifying?
Absolutely not.
As a lawyer, is it appropriate to contact another lawyer about their client?
Objection, Your Honor, as to this witness being qualified to speak about what are in the ethics.
I would hope that every lawyer in the state of Georgia is qualified to speak on what we're expected to do under our code of ethics. I'm going to overrule that.
Would you repeat the question, please?
In your experience as a lawyer, is it appropriate for another lawyer to contact you about matters concerning your client?
That's Law School 101.
And is that what I did on Thursday, June 6, 2024?
Yes.
Mr. Melnick, before you got in, well, your testimony is you were involved representing Mr. Copeland
Yes.
throughout this entire period, correct?
Mm-hmm.
Before you emailed the district attorney's office about their communications with your client that you were unaware of, to your knowledge, had Mr. Copeland been granted any sort of immunity or legal protections for his testimony?
To my knowledge, no.
Okay. After you contacted this district attorney's office and actively communicated with them about your client, what protections was Mr. Copeland granted?
Use immunity.
I have nothing further. Thank
All
you.
right. Any other defense attorney with questions for Mr. Melnick?